My name is David Ashton. I'm head of the property department here at Ricks & Case Solicitors. We thought it would be helpful to outline what needs to be considered when a tenant wishes to take a new lease of commercial premises. We will look today at taking a new lease of office premises and what we need to consider when negotiating the heads of terms with the landlord. I'm joined by Andrew Harfacree of Flood Commercial, a Brighton and Chichester-based property agent, to assist in advising my client in the proposed transaction. Andrew, as you know, our client is looking to take a lease of premises, and you've kindly identified this particular property for our clients, following some questions that you asked about their wants and needs and requirements.
Yes, we regularly acquire and let space, office space for landlords and for tenants, and we know the sort of questions to ask, and those will include typically the number of staff they wish to accommodate. That will influence the size of the space, whether they wish to be open plan or cellular. Other issues include costs, rent, rate, service charge, location, do they wish to be close to a station, car parking, whether they wish to be in a multi-let building or a self-contained building, for example.
As you know, my client is looking to accommodate 40 to 50 people in this space and to have 4 meeting rooms and some cellular offices, a breakout space and also kitchen facilities. Do you see there would be any difficulties accommodating that?
No, that will be fine within the space within a typical office floor as we have here. Modern office building, it's open plan, it's capable of being adapted to suit a particular occupier's needs, so they can fit it out how they require.
Presumably we are going to need to have the landlord's consent to making any changes or alterations to this property.
Yes, that's right. What you'll need to submit is a plan showing the alterations that the occupier wishes to make to the space, together with a methodology, how they propose to undertake those works. That information will go to the landlord. They'll consider that, and any questions they have they'll ask, and once everything is addressed sufficiently they'll issue a licence to alter to permit the tenant to undertake those alterations.
I suspect that the offices that they want to create will be demountable partitioning, and I was wondering whether or not it would be dealt with at heads of terms or in the lease when I negotiate it, whether or not we can avoid having to get the landlord's consent for the demountable partitioning.
That can be dealt with at heads of terms. It's a common request from office occupiers. Most office landlords will consent to that sort of request, and I see no problem with that.
Good. The office space doesn't have any toilets, and I noticed there's sort of air conditioning. Is this all part of the common parts? How does that work?
Yes, within this building the WC accommodation is within the common parts. It's a multi-let building with a number of different tenants in. The WC accommodation is operated and run by the landlord, and the costs recovered through a service charge. The air conditioning within this building is controlled floor by floor and by the tenants directly, so the tenants to this floor could arrange their air conditioning as they wish and control it as they wish.
Good, that's helpful, because I will need to know what rights my or our client needs to have in order to have access to those common parts, those toilet facilities, and also potentially if we have an obligation to repair or maintain any of the plant, we will need to have access to presumably the roof space or the cabling. Are you able to show me where the common parts are and the ducts relating to that?
Yes, I can take you to show you those.
Thank you. Andrew, I think the client will be interested in the property, and I think really what we need to discuss is what we can propose to the landlords in the way of heads of terms to take it forward. What are you able to help and propose as far as that's concerned?
Well, I'd in the first instance recommend that the client take some advice from a local agent. The agent will know what's available in the local market. But in addition to that, when it comes to negotiating terms, they'll know what's going on in terms of rents, rent-free periods, capital contributions, length of lease, break options, and so on.
I think the client will be looking for about a 5-year term. What sort of rent-free period are we going to be looking at there?
Typically in the office market, as we speak today, rent-free periods of around 6 months are being negotiated on lease terms of 5 years.
I suspect that the client will want some flexibility if they expand as they hope to do so, or if there is a further downturn in the economic climate, then we'll be looking to have a break clause. Would that seem feasible?
Yes, I think in the current market in particular, there's a very common request from tenants, and I don't see a problem with that. A landlord may wish to restructure the rent-free period slightly, so perhaps some of the rent-free is granted after the break option has passed.
Looking at the property, it looked in fairly good condition, but I was wondering whether or not we should have a schedule of condition to identify what the property is at the beginning of the lease, so that our repairing obligations are set out in the lease only to keep the property in the same condition as at the beginning of the lease. Would you be able to help on that?
Yes, I'd recommend a schedule of condition when acting for a tenant, particularly on second-hand property, and again, if the property isn't in good condition at the outset of the lease, the schedule of condition will help to protect the tenant on their dilapidations, liabilities at lease expiry.
Excellent. So we've also talked about license for alterations, so hopefully you will put in the heads of terms the condition that we won't need to get the landlord's consent if we're only putting up demountable partitioning.
Yes, we'll certainly make that request.
We also identified that there was air conditioning in the offices, but it's probably going to be something that my client will want to have a survey on to assess really whether or not that is capable to cover the sort of uses they're going to put in and use the offices for. I'll be checking the planning permission relating to use, but also we may need to consider getting planning permission for any additional plant that we need to put on the roof in the way of air conditioning units if necessary. So that will obviously have a timing impact that we'll have to consider depending on those inquiries. Would you be able to assist on the survey?
Yes, it's essential to make sure that the appropriate planning consents are in place. And you also mentioned that the client may need 3 car parking spaces.
Yes.
That's something that we'll look into, because I'm not sure that there are 3 car parking spaces available with the building. So we'll need to establish that with the landlord. If there isn't car parking with the building, then we'll look into sourcing 3 car parking spaces in the immediate locality.
I think therefore we probably should look now to make an ambitious offer, and so if you could put an offer to the landlord's surveyors, what terms do you think we should now set out?
Yes, I'd recommend making an ambitious offer, particularly in the current environment. I'd recommend submitting an initial proposal on the basis of a 5-year lease with a 3-year break option, 12 months rent-free, the ability to assign or sublet as we require, and 3 car parking spaces.
Good. I think once we've made the initial inquiries about the elements that will impact on timing, then we'll look to put that offer to them and any other terms and conditions that arise.
Yes, well, time is a critical issue. If we've got a deadline by which we need to take occupation, then we may need to concede on some of these points as we negotiate to make sure we achieve that time frame.
Thank you. I'll be in touch.
There we have it, a typical scenario with regard to the early stages of negotiating heads of terms with regard to taking a new commercial lease. Terms, of course, may differ depending upon the property and its use, but the points that have been made, if taken into account, should lead to less negotiations having to take place between the lawyers, and hence this should assist in less costs being involved and also early occupation by the tenant. Once all of the terms are agreed, then the details are circulated to all of the parties and their solicitors. The landlord solicitor will prepare the draft documentation and submit those documents to the tenant solicitor for approval. The tenant solicitor will undertake due diligence, enquiries and searches, which will then hopefully lead to the successful conclusion of the transaction. If you have any further queries or questions relating to any of the matters that you have seen, please do not hesitate to contact me, David Ashton.